हमारा मानना ये हमारा एप्रीहेंशन ये है कि deliberately uniforms there is a reasonable apprehension that by deliberately confounding the difference between UCC on the one hand and piecemeal reform of family law on the other, the present government wishes to avoid political consequences of obliterating the diverse customs prevailing in various Hindu communities that are presently protected under various applicable statutes, avoid dealing with tribal practices that have been granted protection or a constitutional scheme, and skirt the issue of tax benefits available to Hindu undivided family, each of which is necessary concomitant of a UCC that is enforced throughout the territory of India. Instead, it is reasonably feared that such an exercise will merely isolate Muslim personal laws and subject them to a reform process solely for political gain and justify this process as being in furtherance of mandate Article 44, thus claim fulfillment of election promise. अब आप ये देख लीजिए, अब ये उत्तराखंड में जो हो रहा है, एक कमेटी बनाई गई, कमेटी ऑफ एक्सपर्ट्स ऑन लॉज रेगुलेटिंग पर्सनल सिविल मैटर्स, यूसीसी उत्तराखंड, वो एक नोटिफिकेशन दिए 27 मई 22 का. हमारा मानना ये है, इट इज नॉट इन फर्दरेंस ऑफ आर्टिकल 44 of the constitution. Any code of law applicable only to one state is by its very definition not uniform throughout the territory of India, which is the clear language of Article 44. Therefore, it is clear that both at the center as well as the state level, the bogey of UCC is being raised only to target the Muslim community and polarize the atmosphere of political mileage. अब आप ये देख लीजिए, हमारा जो प्रीवियस ऑब्जेक्शन का फर्स्ट पॉइंट क्या है, इस देश में इमेंस डाइवर्सिटी है विद इन वेरियस ग्रुप्स और द लीगल ट्रीटमेंट. अच्छा, जो लीगल ट्रीटमेंट विच इज मेटेड आउट टू कल्चरल कम्युनिटीज डिफर्स इमेंसली एंड इज नॉन यूनिफॉर्म. For example, Muslims and Christian citizens of the country cannot access tax rebate under Income Tax Act available to Hindu undivided families. This reflects not only a mistreatment of how Muslim and Christians are treated in the country, but also reflects how accumulation of caste capital continues to receive legislative and constitutional protection. It is obvious that Adivasi and Dalit communities do not have access to accumulated intergenerational capital and therefore cannot seek taxation benefits under existing legislation. Secondly, the term UCC appears in directive principles. The law commission has not clarified again how uniform is confused with the common civil code. It must be emphasized that our constitution makers clearly noted that code will never be imposed on citizenry merely because of citizens. Third, unlike Hindu law, which operates on strictly priestly and legislative interpretation, Islamic law, along with Adivasi and Dalit social practices, is not uniform and extremely contingent on context, cultural practice, social relations. Therefore, one sees that despite a permission of polygamy in the community, Muslims in practice rarely practice it. In other words, Muslim personal law and equal gender rights are never seen as contradictory but consistent with each other in practice. Fifthly, for codified Hindu law, family and social relations are extremely diverse within communities. For example, in Hindu Marriage Act under Section 2 recognize the rights of Adivasi communities to continue practicing their own customary law. Similarly, within Muslim various groups and subgroups observe extremely varying practices. Each of these practices is considered by such groups to be within the umbrella of Sharia or Muslim personal law. Such communities include sects such as Shia, Sunni, but also cultural groups such as Kachi Memons and Mapila Muslims and schools of thought, Hanafi, Jafari, Salafi and other denominational schools of thought. Each of these groups' practices are influenced by each of these aspects. What are the aspects? And they cannot be classified into single monolith identity. The diversity of the country is too vast to be raised by single legislation of parliament. 6. Codification of personal law does not equate with equal rights. Besides the example, it must be noted that Hindu Marriage Act 1956 does not recognize that parties to marriage must exercise their consent. इस्लाम में कबूल है पूछते आपको, हिंदुइज्म में कबूल है नहीं पूछते. आपके रिचुअल्स जो मुकम्मल हो जाते, शादी हो जाती. नंबर 1. However, it are completely valid marriage. However, under Muslim personal law, unless the parties agree to marry each other, no marriage is valid. Any vitiation of consent makes a marriage void in Islam. Seventh, a voluntary, secular, non-religious civil code already exists in the statute books in the form of SMA, JJ Act 2000, Indian Succession Act 1925. However, it is recommended a voluntary personal law system also be also recognized. आप recognize करो इसको. Any community that seeks to preserve its distinct religious culture and social practices under Article 25 and 29 of the Constitution must have the legal avenue to do so. 8. The operation of Muslim personal law shows that it is far more progressive than positive statutory laws like Hindu Marriage Act. In awarding maintenance and ensuring social care of women, relevant studies show that women received a significant better deal under Muslim personal law than under laws. The abolition of such progressive and protective measures for Muslim women solely for achieving superficial uniformity will result in absurd amount of injustice on Muslim women. Finally, the impact of abolishing personal and customary laws will not only be felt by Muslim communities in the country, but will also harm constitutional protection guaranteed to citizens of the country. These include constitutional protection to Nagaland, Mizoram under Article 371A, 371G. Furthermore, cultural rights of Adivasi groups under Schedule 6 Constitution are also violated by any common civil code. In addition to religious rights protected under Article 25 of the Constitution, the most significant violation will be Article 29 of the Constitution. अब आप आखिर में देख लीजिए कि the UCC debate is ingrained bias in favor of the religious morality of the majority community. ये पूरा UCC का जो डिबेट है रिलीजियस मेजॉरिटी ऑफ मेजॉरिटी कम्युनिटी को आप इंपोज करना चाह रहे सबके ऊपर. द स्टार्केस्ट एग्जांपल ऑफ दिस इज द लॉ ऑफ डिवोर्स. इसका एग्जांपल दे रहा हूं आपको. जो कंसल्टेशन पेपर 21st लॉ कमीशन दिया था, कंसल्टेशन पेपर proposes that unilateral divorce by a Muslim man should be penalized. The debate in public domain has vilified unilateral divorce, which in turn has prompted petition Supreme Court challenging talaq-e-ahsan, talaq-e-hasan. The two, अब दो ही बचे हुए, the two remaining forms of unilateral divorce by Muslim man. हम ये क्यों बोल रहे? The underlying assumption debate has always been the process of divorce under Hindu Marriage Act 1956 is a superior method. यही तो बोल रहा majority जो morality है. When one more or more of adultery, cruelty, desertion, unsoundness of mind or conversion or other faith has to be alleged and proved before a court in trial before divorce can be granted. Hindu Marriage Act में आपको बताना पड़ता है adultery, cruelty, desertion, unsoundness of mind, conversion to other faith और उसको कोर्ट में प्रूफ करना पड़ता है before divorce is granted. Similarly, grounds are seen in Divorce Act of 1869 of Christians. This applies to divorce between Christian and Special Marriage Act that is usually cited as a shining example of egalitarian uniform law. अब आप इस्लाम में क्या है देख लो आप. इस्लाम में ये है कि पहले तो आप हिंदुइज्म में हम बता दिए आपको कि for cause divorce is intrinsically linked to the religious morality of Hinduism as practiced in many parts of northern India, under which marriage is sacrament that is meant for 7 lifetimes, as well as biblical idea of marriage as a vow before God to be together till death do us apart. In this understanding of marriage, a judge sitting as arbiter of societal morality must find the existence of grave intervening circumstances, which most oftenly qualifies as sin or curse in religion, before the marriage can be dissolved. This is in stark contrast to the Muslim personal law, under which the basis of divorce is the inability of spouses to live together or the choices of either of them to dissolve the marital tie and move on rather than determination of cause or arbitration of guilt. This is in consonance, ये जो Muslim personal law में जो divorce की practice है, this is in consonance with our constitutional morality that has consistently moved in direction of being pro-choice. अब कौन सा एग्जाम्पल है वो? सुप्रीम कोर्ट का केस है शक्ति वाहिनी यूनियन ऑफ इंडिया 2018. सुप्रीम कोर्ट said it has been sublimely borne in mind that when two adults consensually choose each other's life partners, it is manifestation of their choice which is recognized in Article 19 and 21 of the Constitution. Such a right has the sanction of constitutional law, and once that is recognized, the said right needs to be protected, and it cannot succumb to the conception of class honor or group thinking, which is conceived on some notion that remotely does not have any legitimacy. वही बात सुप्रीम कोर्ट शफीन जहां वर्सेस अशोकन केम 2018 में कहा. तो अब इसका ऑब्जेक्टिव प्रिज्म क्या है? द राइट टू चूज नॉट टू बी विथ वन पार्टनर इज जस्ट अ कोरोलरी ऑफ दिस राइट टू चूज वन पार्टनर। अगर मैं चूज कर रहा हूं तो उसको ये इख्तियार भी है नॉट टू बी विथ हिज पार्टनर। Society opinions on the desirability of continuation of the marital relationship, even at the cost of personal happiness, cannot be allowed to stand in the way of right to choose of either party to the marriage. The understanding that most of the world is now moving towards is that any intimate relationship irretrievably breaks down the moment either party to the relationship no longer wishes to be in a relationship for reasons that may not even be able to explain, leave alone proof before a court. Such an understanding respects the choice of each party to the marriage to choose not to be in that marriage. This is the understanding in Sharia or Muslim personal law, where marriage is an agreement between a man and a woman, and like any agreement, it can be dissolved by either side subject to settling of terms of separation, such as payment of just and equitable compensation. That is also reflected in section 125 CRPC and the protection of women from domestic violence 2005 respectively apply irrespective of religion. और आखिर में, सॉरी 2 मरतबा बोल दिया आखिर में जर्नलिस्ट के साथ, तो इसमें और एक जो आपको ये है मुस्लिम पर्सनल लॉ में और दूसरे उसमें आप देखिए शिकाक का एक वर्ड है डिसोल्यूशन ऑफ मैरिज में, शिकाक का। तो बेसिकली दिस रेस्पेक्ट द चॉइस ऑफ बोथ पार्टीज टू द मैरिज टू डिसॉल्व द मैरिटल टाई। तो the vilification in public discourse and by the media of the unilateral nature of the method of divorce available to Muslims actually betrays inherent bias in favor of the religious morality of the majority, which is actually contrary to the constitutional morality as has been demonstrated in the above 2 cases. अब और एक बात जो लोग बोलते हैं सक्सेशन में बच्चों को हिस्सा नहीं मिलता मुसलमानों में, हम उन लोगों को बताना चाह रहे, बल्कि मैं चैलेंज कर रहा हूं, जितने दुनिया में रिलीजन है, कौन सा रिलीजन था जिसने खवातीन को, महिलाओं को प्रॉपर्टी में हिस्सा दिया? वो पहला रिलीजन था इस्लाम, जिसने महिलाओं को सक्सेशन में प्रॉपर्टी में हिस्सा दिया। तो ये जो हाई मॉरल ग्राउंड जो लोग लेते हैं वो मत लीजिए, उनको हिस्ट्री पढ़ना चाहिए। अच्छा, दूसरी बात ये है, ये तो 2005 में हिंदू सक्सेशन एक्ट अमेंड करे उसमें कोपार्सनरी दिया गया। अब आप बोलेंगे इन्हों कैसा बोल रहे, ये सुन लो। आप बोलते हैं कि द शेयर ऑफ डॉटर बीइंग फिक्स्ड एट हाफ ऑफ द शेयर अलॉकेटेड टू सन is not because the daughter was accorded a lower status in Sharia or Islamic law, personal law. It is in fact reflective of the nuanced thinking that pervades Muslim law and makes complete sense in context of who conspectus of the rights available to women. In Muslim law, woman is given a meher. शादी से पहले मेहर देना पड़ता। मोहम्मद साहब बोल सकते, woman is given a meher or dower by a man as consideration of entering into marital tie with him. This meher is substantial sum that must reflect the financial standing of the husband and is to be paid prior to the consummation of marriage or immediately thereafter unless the wife agrees to delayed payment. The woman is the sole owner of the meher, number 1. Husband se mil raha, which she thus obtains from her husband. As such, a woman has 2 sources of secondary wealth, one from her parents and other from her husband. As opposed to this, a man had only one source of secondary wealth. माने एक आदमी को inheritance from his parents and was required to incur the significant expenditure of having to pay his wife meher in order to get married. Therefore, equity demanded that shares of the son and daughter in the inheritance be fixed accordingly so as to do justice to both. इस्लाम में हस्बैंड के ऊपर जिम्मेदारी बीवी की है, बच्चों की है, उसके माँ बाप की है। बीवी अगर काम करती है, जैसा कोई मुस्लिम जर्नलिस्ट है या लॉयर है, डॉक्टर है, उन्होंने जो कमाते वो उनकी प्रॉपर्टी है, उसमें हस्बैंड का कोई शेयर नहीं है। ये बात आपको समझ, ये जो बार बार प्रोपेगेंडा करते, ये झूठ है, ये सच्चाई है। अच्छा, अब जरा मैं जो बोल रहा हूं, जरा तकलीफ हो जाएंगी बहुत से जो लोग इस पे चिढ़ते ये सक्सेशन के ऊपर. This distribution appears to be inequitable when seen from prism of the Hindu understanding of distribution of property only because of perception bias. Women in Hindu society historically didn't get this right. वहाँ कन्यादान होता था, अभी भी होता. A part of family wealth had to be given as dowry to the husband as consideration for accepting the daughter. Number one, इसको कोई deny नहीं कर सकता. This dowry was given to the husband family and such did not add to the woman's individual wealth that she controlled. अगर आप डाउरी दे रहे तो बच्ची को नहीं मिल रहा, वो तो दूल्हे मियाँ को मिल रहा. यहां पे क्या हो रहा, दूल्हे मियाँ उल्टा दे रहे. In this model, the man has two sources of secondary wealth, one from his in-laws and other by way of inheritance from his parents, while the woman has only one by way of inheritance from her parents. In this context, fixing equal shares of son and daughter in the inheritance may appear to be more equitable. However, even this appearance of equity is misleading. Despite the Dowry Prohibition Act 1961, the practice of dowry continues unabated in India. Each family exceeds its means in giving dowry to the husband family in marriage, both because it is seen as a reflection of status as well as because otherwise it may become ground for harassment of the daughter. After having transferred a considerable portion of their wealth in terms of money, jewelry and movable property to the husband family, to give an equal portion of inheritance to the daughters grossly skews the balance in favor of daughter and makes the distribution inequitable. The immediate consequence of this is that each family must then look to recoup this lost family wealth by demanding it from the family their son marries into, which makes dowry a self-perpetuating social evil. Once again, our constitution has taught us equality does not mean distribution of equal shares to all, but involves a more nuanced understanding of differences and allocating shares that are equitable on a more holistic view of how different individuals are differently placed. Therefore, Muslim law of succession is in fact more equitable given the complete paradigm of personal law that it sits within. And if we don't ask the majority to abandon their customary laws in favor of this more equitable system, we should at least demand and expect that Muslim law be spared the majority's clamor for uniformity. Conclusion में हमारे नोट में ये है, we urge the Honorable Commission to not to allow itself to be made a tool for political propaganda simply on account of the approaching election and drop this enterprise. However, if this Honorable Commission wishes to proceed with exercise, it must do so with seriousness and meaningful way, explaining what it means by Uniform Civil Code and placing a concrete proposal for public comment, giving adequate time for stakeholders to respond. Our country comprises of communities that are diverse and far removed. Adivasis of Madhya Pradesh, Bodos of Assam, Madigas of Andhra Pradesh, Telangana, Siddhi Muslims, Kachi Memons, Gujar Bakrawals of J&K. Our constitution gives each of them the right to conserve their way of life and recognize their personal laws and customs. I would urge this Honorable Commission to recognize this legislating away personal laws to follow such unclear goal of uniformity will mean that it will undo the gains made under 73 years of working of our Constitution, where each of these personal laws have been refined by constitutional courts. Before concluding, I would reiterate that any attempt to creating a mandatory UCC today will go against Article 19, 25 and 29 of the Constitution of India and undermine the intent and purpose of founders of Article 40,